Good afternoon, everyone. Welcome back to day 2 of Supreme Court Week here at Woodward Academy. We are in Gresham Chapel, where you are going to hear 2 separate cases today, back to back. The first case is Bailey versus United States, and the second case is Evans versus Michigan. But before we get to the cases, let me introduce the people who are in our studio today. Off to my left, I have my esteemed colleague, Ms. Maggie Berthume, who will be providing color commentary on these cases. And to my right, I have flanked here Mr. Bill Batterman, who will also provide some color commentary for these particular cases. Now, for the people in the gallery audience and for the people who are watching online, please feel free to chat with me live while the proceedings are going on at todaysmeet.com/BKJ. So that would be TODAYSMEET.com/BKJ. Now, let's talk about these cases, if you wouldn't mind, counselors. As the former ACLU attorney, why don't you handicap the Bailey case for us first?
Bailey is a case about detention. And it's really a case that the Supreme Court took in order to clarify their 1981 ruling in Michigan v. Summers. In Michigan v. Summers, they ruled that the police have a limited ability to detain individuals while executing search warrants of their premises.
And what is the issue in this particular case?
In this case, they are clarifying whether whether that level of detention extends to detaining someone who was away from the home at the time of the search and didn't know the search was taking place.
Okay, I guess we'll see what the lawyers argue and what the justices rule. All right, Mr. Batterman, let's talk to you a second about the second case we're about to hear, which is Evans versus Michigan. What are your thoughts on this particular case?
Evans versus Michigan is an interesting case. It involves the question of double jeopardy, which is an issue that the Supreme Court has litigated many times, and in particular, it's an issue of judicial sort of mistakes, and whether judicial mistakes can prevent the state from retrying a criminal for an action that the court made a mistake during the first trial on. So in this case, an individual, Evans, was tried for arson. The judge mistakenly required the prosecution to demonstrate that the dwelling was occupied at the time the fire was set, which is not the standard in Michigan. And as a result, the judge issued a directed verdict of acquittal. The state would like to retry Mr. Evans on the grounds that he never was really tried, and that this doesn't meet the standard established in U.S. v. Martin Lennon, the 1977 case that is most directly applicable in this instance. So the court will have to decide whether the state gets another crack at Mr. Evans or whether Mr. Evans is off the hook because of a mistake by the judge in Michigan.
All right, well, we'll see what the Supreme Court has to say. All right, now, I believe that the Supreme Court is ready to proceed, and we will turn our cameras away from WA Live Court TV and turn them towards the courtroom as the justices come down to start the proceedings.
All right. The United States Supreme Court is now in session. The Honorable United States Supreme Court Justices presiding. The 2 cases on the docket are Bailey versus the U.S. and Evans versus Michigan. You may all be seated.
Thank you. And our first case is Bailey versus the United States. Is that correct? So the attorney for Bailey, are you ready to proceed? The attorney for the United States, are you ready to proceed? All right. If the attorney for Bailey would please take the podium, you have the court's attention.
Hello, my name is Mac Reese, and I will be representing Bailey in the case Bailey versus U.S. On July 28, 2005, 2 officers of the Suffolk County Police Department arrived to the address of 103 Lake Drive in Wyandanch, New York, after receiving reports of illegal activity going on the first floor of a 2-flat apartment. As they were arriving to the scene, they witnessed my client, Chananel Bailey, and Brian Middleton leaving and driving off without knowing. The 2 officers followed them and then later on pulled them over a mile away from the residency. After pulling them over, the 2 officers forced Bailey and Middleton out of the car to give them and the car a pat-down, only finding a key to the apartment. The 2 men were then detained and taken back to the apartment for so that the officers could execute the search that they came for. Later on, they did end up finding cocaine and illegal weapons, which led to the immediate arrest of Bailey and Middleton. But the real issue of this case is that they only had 1 warrant for the 3 searches they executed. Not only the apartment, which they did have a warrant for, but Bailey and also the car, which this violates the 4th Amendment, which states that people have the right to the unreasonable search and seizures. So in the end, this violates the Constitution.
So you're arguing that the search of the car and the search of the person were unreasonable and were not included in the warrant that was to be executed?
Yes, Your Honor.
Was there any reason for their behavior for leaving and fleeing the apartment complex that causes you concern?
Not that I know of. I just believe that they left the apartment just to go, and it was while the officers were arriving, so they obviously suspected that they could have been the men in charge of the illegal activity.
If they had executed the warrant as stated and gone into only the apartment, would it have changed what they would have found?
Not necessarily what they would have found, but how the case would have turned out.
Okay. Any other questions from the justices?
Yes. Were the drugs and cocaine that the officers found your clients?
Yes, they were proven to be. But it was after they had executed 2 searches that they didn't have a warrant for, a mile away from the residency.
Any other questions? Was there anything that they found or discovered in the first 2 searches that leads you to believe that the 3rd search would have been different?
Not necessarily, just that all they found was a key to the apartment in those 2 searches.
Okay. Thank you. Attorneys for the United States, podium is yours.
My name is Will Crane, and I am representing the United States in the court case Bailey versus the U.S. In the year of 2005, Chananel Bailey, the main defendant, was leaving his residence in New York, not knowing the police force was watching him, and had been for days. At this time, the police were suspicious of drugs in his basement of the residence, and had received a search warrant. The mistake that caused the case was about a mile down the road. They pulled him over, patted him down, confiscated his keys and wallet, and drove him away in the police car. This gave Bailey the ability to testify with the reason of his Fourth Amendment rights being invaded. Shortly after, they arrived back to his basement, in which police had a warrant to search. They obtained the cocaine and a gun from the search. Bailey was charged with possessing cocaine with the intent to distribute and possessing a firearm as a felon. Bailey now argues that his Fourth Amendment rights have been invaded throughout the search and seizure because he was not present at his residence when confronted by police, but was forced back by the police to be searched. In a previous case called Michigan versus Summers, it was announced that police may detain an occupant outside the premises to be searched as long as the search was reasonable. The reasoning underlying Summers justifies the detention and that any Fourth Amendment issues can be resolved by a reasonable test. Also, in the court case Michigan versus Summers, it was decided a search warrant for the occupant's home extended to a point where the person himself was to be searched outside of the residence, if necessary.
Do you think the distance between the apartment and when the search of the person took place was reasonable?
Yes, sir. A mile is not that long.
Okay. Questions?
How come they didn't execute the search warrant before, or the search warrant for the apartment before they went and got the defendant?
They were on their way to search his apartment when they saw him leaving the apartment, and it took about a mile down the road for them to catch up to him.
But I think Justice Ginsburg is wondering is why they didn't go to the apartment and why did they follow the perpetrators or the suspects? Was there a fear of flight?
I think, yes, sir. Yes, sir, there was.
So the officers were basically knocking on the door when they pulled out?
Yes, sir. All right. Yes, sir.
Was the warrant only for the basement of the apartment, or was it for the whole apartment?
It was for the upstairs of the apartment where the drugs were found.
Any other questions? Thank you. And if Bailey would like to rebut anything, now would be your opportunity. Okay, great. Well, this concludes this portion. I believe we will be going right into Evans versus Michigan before we go into recess. So we thank you for your time, and if the attorneys for Evans and Michigan would like to approach the podium, you can do so at this time. So again, the second case that we'll be hearing this morning is Evans versus Michigan. Are the attorneys for Evans present and ready? And the attorneys for the state of Michigan? All right. So first, the attorneys for Evans would approach the podium. You have the court's attention.
My name is Olivia Resnick, and I'm representing Evans in Evans versus Michigan. On September 22nd, 2008, Lamar Evans was charged for burning other real property. Evans was seen outside the burning house with a gasoline bottle and was taken into custody by 2 Detroit police officers. After he was detained, Evans gave an incriminating statement. During the trial, the court made the prosecution establish if the building was a dwelling, even though it was not expressed in Michigan's laws. The counsel observed that the standard jury instruction for burning other real property included an element that the burning building could not be a house. The counsel then pointed out that 2 witnesses had testified that the house was inhabited. Therefore, the burned house was excluded from the definition of other real property, because the only evidence in this case is that it was an occupied dwelling or that it was being lived in. In response, the judge acknowledged the defendant's proposal of an acquittal. Respondent filed an appeal to the Michigan Court of Appeals. The court reversed the directed verdict and ordered a new trial. The court ruled that the double jeopardy clause that gives the defendant the right to not be tried for the same act twice was not broken because the information was not reviewed due to the verdict of acquittal. Evans appealed to the Michigan Supreme Court, in which he argued that the double jeopardy clause barred a retrial. The issue at hand boils down to 2 factors. 1, allowing a mid-trial and letting the defendant be declared innocent based on the fact that the judge had not had the prosecution prove a factor that was not needed. And 2, determining if the double jeopardy clause prohibits retrial after the judge wrongly deemed a factor to be an offense. In cases such as Smallis versus Pennsylvania, similar happenings occurred where the court made errors by adding an extra element that was not required for the verdict to be determined. In Smallis, a married couple was charged with a variety of crimes that correspond with a fire in which a building they owned had killed 2 workers. At the end of the trial, the couple was acquitted, and the appeal filed by the Commonwealth was barred because it would lead to more trials, which was prohibited by the double jeopardy clause. In similar fashion, Lamar Evans was acquitted on February 23, 2009, when the court judge ruled Evans innocent of charge. I would like my client to be released because not only has he been tried for this crime already and declared innocent, he is being punished further for a mistake made by the judge. And based on the Constitution's double jeopardy clause, he is protected from being tried twice for the same offense. The double jeopardy clause prohibits subjecting a person to a post-acquittal case, so like what happened in Smalls versus Pennsylvania, my client should be free to go.
Do you think that the intent of the Fifth Amendment was to prevent a trial in a case where a mistake had occurred?
Yes, sir. I think it goes with like any case because it was made to prohibit like being retried on the same account like dozens of times.
What is this for the sake of harassment from the government?
Yes, sir.
Or is it a matter of making sure justice is reached?
I think it has to do with both of them. My client had been declared innocent, and now there's a new trial, which is clearly prohibited in the double jeopardy clause.
Questions for the attorney?
Was he found innocent in a lower court? Because technically, if he was found innocent in the lower court, he can still be brought to the Supreme
He was
Court.
found innocent in the first court, yes.
If the accused makes a mistake, they get a retrial. So why is that different for the prosecution?
Because he was, it was the judge that made a mistake, not the, people, not Evans or Michigan. Or no, it was Michigan, so yeah.
Okay, thank you. This time, the attorney for the state of Michigan. You have the court's attention.
Hello, my name is Arfan Kawaja, and I represent the state of Michigan in the Supreme Court case, Evans versus Michigan. On September 28, 2008, 2 Detroit police officers were scouting the area for any suspicious needs around a neighborhood. They found a house that was burning down, and they saw an African-American male man who was running away from the scene with gasoline in his hand. They stopped him, but when they asked who he was and if he had any problem with the house burning down, he didn't reply at all. Then when they asked the second time, he said, "My name was Lamar Evans," and it was a complete misunderstanding. So the issue is that under the Fifth Amendment, the state of Michigan prosecutes Evan again when the trial court mistakenly acquits the previous case. Evan uses the Fifth Amendment double jeopardy clause, saying that they cannot prosecute him again for the same crime. Now, going back to the first trial, the judge had made a mistake by saying that the house that was burned down was in fact a dwelling, not a house, not a vacant house. Now, this is arson, basically. So I quote this from Michigan Code of Law 750.73. Burning other real property, any person who is willfully, miscellaneously burns any building or other real property or any contents of theft, not theft, my mistake, thereof, other than those specified in the next preceding section of this chapter, of the property of himself or any other, shall be guilty of felony punishable by imprisonment of the state of Michigan for no more than 10 years. So Evans was never put in jeopardy. In the first case, he was acquitted, but the definition of an acquittal in the previous case, United States versus Martin Linen Supply Company, the definition of acquittal for them, which later on is today the same definition, the normal policy granted the government the right to retry a defendant after a mistrial that does not determine the outcome of a trial. That does not apply here, since valid judgments of an acquittal were entered on the express authority of and in a strict compliance with Rule 29C. And a successful government appeal reserving the judgments of an acquittal would necessitate any other trial to further proceeding to resolve factual issues going to the elements of the offense charged. Thus, the state of Michigan court held that Evans was not entitled due to double jeopardy protection. When the Michigan court came to a conclusion and removes the case from the jury before it deserves a verdict, the state of Michigan says since Evans chooses to end the trial early before a verdict, reviewing that dismissal does not take place, defendant in double jeopardy a second time. So, in conclusion, I would like the Supreme Court to prosecute Evans for arson, and that double jeopardy is not appropriate in this case.
Let me get this right. You're suggesting that the first case did not reach a conclusion?
They did not reach a conclusion. The definition of acquittal says that an acquittal does not actually grant someone innocence or, innocence.
So in your mind, what is the point of the Fifth Amendment and freedom from double jeopardy?
Well, in Fifth Amendment, it states that no person shall be prosecuted twice for the same crime, and no person shall be prosecuted for the same crime twice of life or limb. When you mean by life or limb, they mean by life, meaning actual having your life and staying alive, not dying, and limb, meaning that your limbs are actually in prison. So Evans was, after it was acquitted, it wasn't actually possible for double jeopardy to actually happen because he was already acquitted. And so the state of Michigan, the court, they took back the acquittal and prosecuted him again.
But to be clear, your definition of limb, he would face jail time if found guilty.
Yes.
Okay. Questions from the justices? Okay. Thank you. And if the attorney for Evans would like to rebut? Okay. Well, in the interest of time, we appreciate your time today for both of these cases, and we will take them under advisement. The United States Supreme Court is now adjourned.
All right. The United States Supreme Court is now adjourned.
All right. Welcome back to WA Live Court TV edition. I am back in the studio, flanked by my colleagues on my right and my left. Once again, to my left, we have Ms. Maggie Berthume, and flanked to me on my right, we have Mr. Bill Batterman. All right, counselors, you heard the arguments that were made before the Supreme Court justice today. Before we actually talk about the case, let's talk about the attorney performances. We started with Ms. Berthume the last time, so let me start with Mr. Batterman this time. All right, Mr. Batterman, how would you critique the lawyer's performances in the first case we heard, Bailey versus the United States?
Bailey versus the United States. I think that the two attorneys left a lot of the legal arguments out of their presentations and spent too much time describing the facts of the case, which I don't think are at issue. I don't think that either side contests what happened. The question is just whether the search that occurred was legitimate without a warrant for the car and for the individual a mile away. And so I think
your critique would have been that they should have focused more on the argument analysis portion,
Yeah.
and less on the
Less
factual,
on the facts of the
since
case.
they
'Cause
weren't
they don't,
an issue.
everyone knows what happened. The question is, was it reasonable for the police to follow Mr. Bailey that far and then conduct a search?
Okay.
And I think that the justices are going to have to rely a lot on the friend of the court briefs and on their background knowledge to resolve that issue.
Okay. Now, Ms. Berthiaume, why don't you talk to us about the performances of the lawyers in the second case we heard, Evans versus Michigan?
I think the lawyer for Evans did a good job of articulating the issue at hand, but could have used more precedent and other types of argumentation in order to explain how those issues did or did not apply in the Evans case particularly.
Okay.
Whether double jeopardy applies in this case is something that obviously is going to be a thorny issue for the Supreme Court to sort out, and I think that could have been a little bit clearer. As for the judge from Michigan, I think that he struggled to articulate a coherent vision of the Fifth Amendment. Obviously, there are some difficulties for Michigan here, given that they do want to try the same case again. But I think that he really needed to focus more on the idea that the court had not actually charged him with a real crime, and thus he was not, his life and limb was not perhaps threatened. But in this case, he made some specious arguments about why his life wasn't threatened in general that I just don't think applied to this case.
Okay. All right. Let's switch gears a little bit, and let's talk about the actual cases themselves. Mr. Batterman, how do you think the handicap the case for us? How do you think the Supreme Court is going to look at the Bailey versus U.S. case?
Bailey, well, I think that the court definitely wants to provide some flexibility to law enforcement to conduct searches while maintaining the kind of sanctity of the search and the protection of the officers and the area around the search. Whether that will extend so far from the premises of the search, maybe not. I think that they will probably clarify the existing precedent in Michigan v. Summers and probably provide a little bit more guidance to police officers. I don't necessarily think that they'll throw out this search. It would have been interesting to hear more of a discussion of the reason that the police had to conduct the search at the time they did. It seems like they had been staking out this place for a while. I don't know why they had to go after the defendant or the suspect at the time. But it's a tough case. I think ultimately the United States will win, maybe with some narrowing of the requirement in Summers.
All right. Even though the search warrant that the New York State Police had was solely for the apartment, you still think that someone drives a mile away from the apartment, that search warrant still covers the suspect and his car as well?
I think that the argument that the court will find persuasive is just that the detention was part of a search of the house, and that the geographical proximity is not as important as the intention of the police officers and their discretion. The court is hesitant to place too many restrictions on the police's discretion in the interest of maintaining strong law enforcement. I think the conservative justices probably will prevail on that issue, but there could be some narrowing or some clarification of what it means to detain someone on the immediate premises. They might provide some more guidance to law enforcement.
So from your perspective, a mile is okay? Would
I
2
think
miles be too far?
I think that's
Would
the
5
issue
miles
that's
be
in
too
front of
far?
the court. I think the court will have to decide whether it's really geography or whether it's that the detention is to facilitate a search, so regardless of where the individual is.
Well done. All right. Now let's turn to you, Ms. Berthiaume. Handicap the case of the Evans versus Michigan. How do you predict that the Supreme Court's going to decide this case and why?
I think Evans has a pretty good chance in this case. I think
Why is
even
that?
the most conservative justices are not likely to reward trial judges who make even egregious errors. And it's a challenge to let an arsonist go free, that the alternative of adding a layer of confusing, is this an evidentiary problem or is it an element of the trial problem, is not going to bear out in real life, that would be difficult for trial lawyers, and so I think they're going to come down on the side of Evans.
All right. So you think that even though that Mr. Evans is an admitted arsonist, that you think this court is going to let Mr. Evans go free because the judge made a mistake about the law?
I do, actually. I think it's, it is clearly unfortunate that the court needs to send a signal to trial jurors that their mistakes have real consequences, and that it is likely that they took the case in order to do so.
Okay. All right. Well, guess what? We will soon find out, won't we, with respect to what the actual Supreme Court decides as they are about ready to line up and process, and they're going to come back in and give us their particular verdict. So, thank you very much for watching WA Live Court TV version. We'll turn back to the courtroom where the Supreme Court is about to render their verdict.
All right. The United States Supreme Court is now back in session. The Honorable U.S. Supreme Court judges presiding.
You may all be seated. In the first case heard by the Supreme Court today, Bailey versus the United States, the Supreme Court finds 8-1 in favor of the United States. In the case of Evans versus Michigan, the court has ruled 5-4 in favor of Michigan. This concludes our proceedings. The court is adjourned.
Okay. You all have 5 minutes before